Every relationship and every commercial transaction, every professional agreement has one common thing, that is the valid contract. Now, tell me what makes the contract truly valid? What are the terms and conditions after they getting fulfilled? It says that now the contract is valid. Why every agreement is not a contract, and why every contract has a base of agreement? What happens when the parties breach the agreement? Now, all this answer is being given in the Indian Contract Act of 1872. This is the act which was published in 1st September of 1872. So yes, welcome to the legal knowledge update, and today here in this video we are going to understand that how the contract is formed, what happens when it get breached, and what are the fundamental definitions according to the section 2 subclause H of this act says that about the valid contract act. So let's begin with the video and hope you'll enjoy it. Hey everyone, now today we are going to start with the fundamental definitions and some important tips and tricks which I'm going to share with you all in this video. So let's start. According to the section 2 subclause H of this act, it says that a contract is a valid contract only when the agreement is legally enforceable by the law. Means for a valid contract the agreement should be legally binded by the law, which means two things in the statement: that first, for a valid contract, agreement is must. And most important point is legally enforceability. Without the legally enforceability, an agreement is just simply a promise. Okay, so what do you mean by the term basically agreement, or what does this term basically refers to? An agreement is a promise or a set of promise forming a consideration between the two people according to the section 2 subclause E. Okay, if this means the agreement, then what do you mean by the promise? When did the promise came into existence? A promise came into existence when the offer is means when the offer was being done. Now what do you mean by the offer over here? It means that expressing a willingness from one person to the another one is offer. Okay, and when the person express their willingness to the another one and the another person accepted, here it refers to the acceptance. Therefore, though this is the reason the offer and acceptance are the starting point of every contract, every valid contract. Okay, offer is also a proposal expressing our willingness to do something or not to do something with the consent of another person is offer, and acceptance means giving assent to the offer. Okay, when the acceptance is communicated in a proper way, here the agreement is formed. Have you ever heard about the statement that every contract is an agreement, but not every agreement is a contract? Why so? Because for an formation of a contract, an agreement is must. We need to form the agreement. Then only we can form a valid contract. Okay. Now the statement is clear. Now come to the statement that every agreement is not a contract. Why? Because for an agreement to be a valid contract, it we should remember, or we should keep an proper check that it should be legally enforceable by the law. Until and unless the agreement is not legally enforceable by the law, it is not legally binded by the law, it couldn't be a valid contract. However, not every agreement becomes a contract. Okay, for an agreement to be a legal contract, there are some terms and conditions. If we talk in the context of section 10 of Indian Contract Act, there are some terms and conditions need to be fulfilled. For example, means first step is lawful offer and a lawful acceptance should be there. Second, the parties must intend to create a legal relationship. Now, if we talk about the parties, here it doesn't mean the social or a domestic one, because the social and the domestic relations are something like friends and families, etc. Okay, so these are some relationships which are never intended in the legal consequences. Clear? Now, if we talk now, we'll talk about the third most essential point, that is consideration. Now, consideration, if I say in the one word, is something in a written. Okay, for a valid contract, the consideration is decided. It is the promise. Okay, it should be in a way that it should be valuable in the exchange under the law. Here it refers to the consideration. Now, the fourth most important point is the act of parties. The capacity of the parties means the parties, those who are coming in the contract, okay, shouldn't be minor. First, it should have the age limit, proper age limit. Second, they should be sound minded. It means the individual shouldn't be minor. Second, it shouldn't be unsound mind. Third, it shouldn't be the person who are rejected by the law. Clear? Now the fifth most essential point is the free consent. Now here the free consent talk about that it must not be misrepresentation. Okay, then it shouldn't be caused by coercion or undue influences. Clear? If a consent is not free, then the contract must either void or voidable from starting. Now the next essential point is the lawful objects and lawful consideration. Now we understood the formation of a contract, what makes the contract valid, what makes the contract unvoidable or enforceable. Okay, so it is important to know that not all the contract is general contract. Okay, some contracts are which comes under the special contract act. Indian Contract Act provides separate sections for these type of contract. Now, why is it important for the CMA students to understand the separate contract act? Because it deals with the real world of business transactions. Clear? It deals with the real world of business transactions. Secondly, it deals with the protection or protecting a law against the laws. Second, how to act against someone's behalf. Clear? Special contract acts are of five types. First is indemnity, then guarantee, then bailment, then the is agencies and pledge. Now let's start with the special contract act and let's understand it. Why do the special contract act exist? What is the reason behind this? What does the special contract act actually means? It's because not every transaction deals with the offer and acceptance. Sometimes in a life we get uncertain situations, like sometimes we repay someone's loan or we protect someone from the loss. Sometimes we kept someone good as a security. Sometimes we act for someone else, or sometimes we act on the behalf of someone. So these are some uncertain situations which comes in a life. So to protect this, to handle this situation, Indian Contract Act of 1872 provide us some separate sections. That's what the Special Contract Act means, and this is the reason here it exists. Now, the Special Contract Act is basically classified into five main branches. First is indemnity. Now, what do you mean by indemnity? Means protection against the laws, where someone promised to protect someone from the loss. For example, means there are two parties into this in this process. First is indemnifier, the one who promised to protect. Second is indemnified, the one who get protected by someone. Okay, now if we understand it with the help of example, let's suppose there are two person A and person B. Person A got bankrupt. He don't have money to solve his problem. Now, by saying this, person B got hurt and he said that I promise you I'll pay your all the loans. I'll protect you from your loss. Correct? Now, here the person A is indemnified because he is the one who is getting protected with the help of person B, and the person B is indemnifier who promised to protect person A from his loss. Clear? Now let's come to the second one. Now, second step, if you understood the first point clearly, it's easy now for you to understand the second step. Second is guarantee. It's same as the step one, but here the third parties enter. Second one is guarantee. Here means there is no physical transfer of a goods, but in real life the physical goods means the many transaction involve the handling over goods. Clear? Now the third here comes to bailment. What do you mean by bailment? In bailment, goods are returned after the use, or sometimes it is kept as a security. So here it refers to the bailment. Now the fourth point is pledge. Now what do you mean by pledge? Pledge means now not all the transactions deals with the involvement of a goods. Sometimes we act for someone on the behalf of him. This is known as pledge. And now here comes to age, the fifth and the most important one, agencies. Now the agencies means the representative who handle all the process. So Special Contract Act cover the five major roles. First is indemnity. Here he plays the roles of protection. Second is guarantee, plays the roles of assurance. Third one is bailment, where it plays the role of handling of goods. Fourth one is pledge, where it kept the good as a security. And the fifth one is agency, who handle all the process in a good way. As we completed with the explanation, I'm going to tell you some tips and tricks that would be easier for you to memorize all the point clearly. And let's revise all the points. Now let's revise from starting. First, we discuss what is contract. A contract is simply an agreement that the law is ready to enforce. Every contract start as a promise, but not every promise becomes a contract. Okay. Now to become a contract, two things are mandatory. First is contract is equals to agreement plus a legal enforceability. Just remember this. To remember this, you can it will be helpful for you to remember the definition. An agreement is just the beginning. Only when the law recognizes it, it becomes a contract. Clear? Now comes to agreement. What is agreement? What is agreement? Agreement means offer plus acceptance. When one person offers something to the other person, accept it, it becomes an agreement. But the agreement alone is not enough. It must fulfill several conditions to turn into a valid contract. Clear? Now third, we'll discuss about the essential of a valid contract. This is the heart of entire act, explained slowly in a video. Okay. First, we discuss about the offer and acceptance. Offer must be clear and specific. Acceptance must be absolute, unconditional, and communicated. Third, if acceptance changes term, it is not acceptance. It becomes a counter offer. Clear? A counter cannot begin if these two do not match perfectly. Now let's come to the lawful consideration. Consideration here means something of value exchanged between the parties. It can be money, service, promise, benefit, or a loss. Now, important for CMA rules. According to the CMA students, agreement without the consideration is void, except in a special cases like love and affection should be in a written, compensation for past voluntary service, etc. Clear? Now, now let's revise from starting. First, we discuss what is contract. A contract is simply an agreement that the law is ready to enforce. Every contract start as a promise, but not every promise becomes a contract. Okay. Now to become a contract, two things are mandatory. First is contract is equals to agreement plus a legal enforceability. Just remember this. To remember this, it will be helpful for you to remember the definition. An agreement is just the beginning. Only when the law recognizes it, it becomes a contract. Clear? Now comes to agreement. What is agreement? What is agreement? Agreement means offer plus acceptance. When one person offers something to the other person, accept it, it becomes an agreement. But the agreement alone is not enough. It must fulfill several conditions to turn into a valid contract. Clear? Now third, we'll discuss about the essential of a valid contract. This is the heart of entire act, explained slowly in a video. Okay. First, we discuss about the offer and acceptance. Offer must be clear and specific. Acceptance must be absolute, unconditional, and communicated. Third, if acceptance changes term, it is not acceptance. It becomes a counter offer. Clear? A counter cannot begin if these two do not match perfectly. Now let's come to the lawful consideration. Consideration here means something of value exchanged between the parties. It can be money, service, promise, benefit, or a loss. Now, important for CMA rules. According to the CMA students, agreement without the consideration is void, except in a special cases like love and affection should be in a written, compensation for past voluntary service, etc. Clear? Now now let's come to this second means next point, capacity of a parties. Now what should be the capacity? First, a person can enter into a contract only if he is 18 plus, means he shouldn't be minor. Okay. Second, he shouldn't be unsound mind. Third, not disqualified by the law. The person who is entering into a contract shouldn't be rejected by the law. The most important rule, minor's agreement is always void from the beginning. Minor cannot ratify the contract even after becoming a major. This is highly tested according to the CMS parents. Means for the CMS parents. Then comes to free consent. Consent must be free if the consent is taken by the coercion like force and threat. Second, undue influences means dominance or pressure. Then third comes to fraud, means intentionally cheating. Then misrepresentation means false statement but without the intention to cheat. Then fifth come to mistake. Okay, then it is not a free consent. The contract becomes voidable at the option of the aggrieved party. Clear? Now, lawful object and a lawful consideration. The purpose of contract must be legal. Agreement for illegal activities like smuggling, bribes, or immoral activity are void. Not expressly declared void. Some arguments are automatically void even if the parties agreed, such as agreement in a restraint of a marriage, agreement in a restraint of a trade, wagering the agreement, or uncertain agreement. Then we discuss about the different type of contract or agreement. First, we discuss the valid contract. All essential elements are present, fully enforceable. Then we discuss about the void agreement, not enforceable from beginning. For example, agreement with minors. Then we discuss about the voidable contract, valid initially, but one party can cancel it because the consent was not free. Okay. Then we discuss about the illegal agreement, forbidden by the law. Related transaction also become illegal. Then we discuss the enforceable contract, technical defective like no stamp cannot be enforced unless the defect is removed. Then we discuss the performance of a contract. Now, the performance means carrying out the promises. Actual performance means the promise fulfilled. Attempted performance means the offer to perform, but the other party refuses. Now, the party must perform exactly what is the promise. Now, we discuss then discharge of a contract. How should be the discharge? The contract ends in the following ways, like first is performance, most common. Then then the second is mutual agreement, novation, alteration, and rescission. Then third should be means by impossibilities. The subject matter destroyed, death, or a war, something like this. Then fourth, the discharge should be operation of a law, by the operation of a law. What does it mean? Means insolvency or a merger. Then fifth, lapse of time, limitation period expire. Then sixth, breach, one party breaks the contract. Okay. Then we discuss about the remedies of breach, that if a contract is broken, law gives the following remedies like damages, specific performance, injunction, rescission, and quantum merit. Now, damages deals with the monetary compensation for a loss. Specific performance are the court orders actual performance of the contract. Then injunction is the court orders a person to stop doing something. Rescission deals with the contract is cancelled. And contract merit means the payment of work already done when a contract is incomplete. Then we discuss about some special contracts, which is very much important for the CM aspirants. General contract tell us about the basic rules, but the special contract tell us how the certain specific relationship work in a business. These are directly used in practical life. First is indemnity, which stand for the protection. Then guarantee, which is assurance. Here the main point is the surety liability is secondary. Debtors is liable first and surety comes later. Clear? Now, in the third one is bailment. Here the bailment means the goods are only the movable goods can be bailed, money cannot be bailed. Then fourth one is pledge. In pledge, gold loan, like gold is a pledge, the special type of bailment where goods are given as a security for a loan. Clear? There are two parties into this. First is pavner, that is pledger, or a pavni, which can be said as pledgee. Correct? Now, fifth is agencies. Is how we completed with the Indian Contract Act of 1872. Hope this was helpful for you all. If any doubt, just let me know in the comment box. So thank you for watching this video and please subscribe, like and share my channel.